Hello everyone, welcome to Sreshtha Purposefully Passionate About Domestic Abuse Awareness series. The intent of this series is to raise awareness of different types of domestic abuse. A lot of persons think that physical abuse is the only type of domestic abuse, but in reality, domestic abuse can be mental, it can be verbal, it can be economic, and a host of other things. The intent of this series is if you relate or recognize situations that we are speaking to, that you are able to make a change, a safe change, either by speaking to your partner, seeking help, or exiting if necessary. Through this series, we speak to survivors, we speak to therapists, and today I'm really happy to welcome a team of lawyers, Jonathan and Renee. Jonathan Bhagan is an attorney at law and president of the Christian Youth Foundation of Trinidad and Tobago. Jonathan also co-founded Operation Global Sex Offenders Registry, which seeks to link sex offender registries in the Caribbean with law enforcement in the United States. Jonathan is a graduate of the Cambridge Institute of Continuing Education Leading Change program and an associate fellow of the Royal Commonwealth Society. Jonathan also graduated from Hugh Wooding Law School and the University of the West Indies. Hi, Jonathan. You're on mute, right? So I'm going to introduce Renee while you unmute your mic.
Hi, thanks for having me.
You're welcome. Renee Joseph is a young attorney at law who is passionate about justice, fairness, and equity. To this end, she uses her profession and advocacy to champion for the rights of the disadvantaged and unprivileged in the society. Renee holds a Bachelor's of Law degree with honors from the University of the West Indies and a Master's of Law degree in International Law and International Relations with emphasis in human rights and gender from the University of Aberdeen in Scotland. Renee is actively involved in youth mentorship and empowerment and maintains as her personal motto, service above self. In her free time, she can be found enjoying a good novel or engaging in a fierce and noisy board game or game of volleyball. She longs for the day when inequality would be eradicated and everyone could have an equal opportunity to fulfill God-given potential and purpose. So thank you so much, Jonathan and Renee, for joining me today. I am excited to talk and share with the audience about rights in domestic abusive situations, how we can prove nonviolent abuse, possible relief in these situations, and I will hand over to you.
All right. Thank you so very much for having me, Sreshtha. Now, I want to highlight, first of all, the United Nations, the Convention for the Elimination of Violence Against Women, because there you would find generally what the United Nations recognizes as the rights of a woman, which you would have mentioned in your introduction. And so they generally purport that women are entitled to equal enjoyment and protection of all human rights and fundamental freedoms. And so these rights include the right to life, the right to equality, the right to liberty and the security of the person, which I think our discussion here would touch upon, the right to equal protection under the law, the right to be free from all forms of discrimination, and the right to the highest standard attainable of physical and mental health. Also, the domestic violence would touch on that. The right to just and favorable conditions of work, and the right not to be subjected to torture or other cruel, inhumane, or degrading treatment. So you see there, the issue of domestic violence would overlap on several of the rights that I would have just named. And each woman within our society is afforded these rights, and governments, through their various private and public sector institutions, have a responsibility to ensure that these listed rights of the female are preserved and protected and even promoted and upheld. And so it is for this reason that our governments would have introduced the Domestic Violence Act. And within recent times, 2020, there was the reformation of the Domestic Violence Act. So it was with a view towards providing a legislative framework that would assist in the elimination of violence against women. So that's my opening thought there, and I would hand over to Jonathan for his opening comments.
Thank you, Renee, for that very eloquent and erudite point. So yes, so there are obligations in international human rights law and under the Constitution for the government of Trinidad and Tobago to uphold women's rights and to eliminate violence against women. As somebody who has been exposed to the field for about 7 years and worked with the Organization for Abused and Battered Individuals, OABI, since 2014, and I'm now into my own the Caribbean Committee Against Sex Crimes. From my experience, it's never really been the law as a major issue in ending violence against women in Trinidad. It's the lack of resources in the system, the lack of training for police officers. So, for example, especially now during the pandemic, it is heartbreaking to have to advise women that due to the lack of funding for domestic violence shelters, most of these women who want to get out of situations with abusive partners and they need to carry their child with them cannot get accommodation. They can call 800 SAFE, and well, I'm not sure as of right now what their policy is, but there was a point in time where you needed a negative COVID test to get into a shelter, and the shelters were usually full very quickly because so many of them shut down over the last few years due to lack of funding. So whenever anybody, and again, it's up to the people of Trinidad and Tobago to hold their MPs accountable, demand that in every budget there's millions of dollars, probably $50 million for funding these institutions, and that is what is going to help. And other than shelters, there needs to be funding for lawyers and legal aid to help women take these matters to court, for counseling, because after many years of abuse, remember, there's as a point, it is still rape where the parties are married. The first case we learned in undergrad and law school, Regina versus our husband can rape his wife. If there's no consent, that is a criminal act. You can take that to a criminal court. That is a very rare occurrence in Trinidad because of the lack of education, the lack of support, and free legal advice. So we need those resources invested in that. And women, after many years of that abuse, it takes counseling and time to recover. So that's where the investment should be.
Okay, and Renee, I want to ask you one thing. You started talking about the definition of domestic abuse as defined by the UN. How is that integrated into our legal framework? And how can that be proven, especially if it is non-violent in a court of law? How can that be proven?
Right. Now, let me tell you, our legislation does in fact define domestic violence. All right. So domestic violence as defined by Domestic Violence Act, which is Act number 45, Chapter 45 of 56, all right? And it was revised by Act number 18 of 2020. So if you're going to Google, you're looking for those two pieces of legislation, Domestic Violence Act of Trinidad and Tobago and Act number 18 of 2020, which revised the Domestic Violence Act, all right? So what it defines domestic violence as: any physical, sexual, emotional, psychological, or financial abuse committed by a person against a spouse, child, or any other person who is a member of the household or a dependent. So you see how very broad the definition of domestic violence is. And the legislation didn't stop there, but because so many times people equate domestic violence with just physical abuse, the legislation went on to define what the other types of abuses are. So we have emotional and psychological abuse, means a pattern of behavior of any kind, very wide language being used again, all right? The purpose of which is to undermine the emotional or mental well-being of a person. And it goes on to describe some of the behaviors. So I'm going to share that with our women.
Yes, thank you.
Persistent intimidation by the use of abusive or threatening language. It includes following the person from place to place. It includes depriving that person of the use of their property. So if your husband kick you out of the bedroom and lock you in and you have no access to your clothes and your toiletries, etc., that's abuse. Watching or besetting of the place where the person resides, works, or carries on business, or even happens to be. interfering with or damaging the property of the person. Forced confinement of a person. So if you find your spouse is preventing you from interacting with your family and friends and they just want you to be home, that's a form of emotional abuse. All right. Persistent telephoning of the person at the person's place of residence or workplace. Where you are now? Why you ain't reach home yet? That's a form of abuse. Making unwelcome and repeated or intimidatory contact with the child or elderly relative of a person. So while they may not necessarily be emotionally abusing you directly, they continue to threaten. If you leave me, I will kill your child. If you leave me, I will burn down your parents' house. That's abuse, all right? So it's anything that causes emotion to affect rather the emotional, mental well-being of a person. The legislation further defines financial abuse as a pattern of behavior, the kind of which and the purpose of which is to exercise control, coercive control, or to exploit, or to limit a person's access to financial resources so that you make sure that the person is financially dependent on you. So we have some cases sometimes where women have to go and request money to purchase sanitary napkins. And that is a form of abuse if you do not have access to sufficient financial resources so that you can live and lead a normal life. Everything you have to stretch out your hand to ask for money, that's financial abuse. You also have the regular types, physical abuse, any act or omission which causes a physical injury. All right. Now, let me highlight, or before I highlight that, let me look at sexual abuse. Sexual contact of any kind that is coerced by force or threat of force or the commission of or an offense or an attempt to commit rather an offense of the Sexual Offences Act. So I endorse what Jonathan just said. It is possible for a husband to rape a wife. If she says no and you proceed to do so by force or by threat of force, then it is in fact sexual abuse. All right. Sexual abuse also entails forcing your partner to do sexual acts that persons may have seen in pornography videos, etc., and they want their partner to perform it on them, and the partner is resistant to doing so. That is also a form of sexual abuse. So what I want to highlight, Sreshtha, is that emotional abuse and financial abuse are patterns of behavior, which means there are certain things that you have observed over time that could be deemed to be emotional or financial abuse. Whereas physical or sexual abuse is any act. So it could be a single act. One cough is enough for you to seek protection under the law. One incident of he choking you to have sexual intercourse with you is enough for you to seek the intervention and protection of the law. So I just want to highlight, these very, you recognize, as I said, very wide language used by the legislation, and it's sort of envisioned a multiplicity of scenarios where abuse can arise.
Yes, thank you so much. I mean, even I myself wondered what is the difference sort of between an unhealthy relationship and an abusive relationship. And I'm glad that you clarified the points in time at which a relationship would become abusive dependent on the type of abuse that the person is witnessing. So thank you for that.
No problem at all. And I want to highlight that the legislation does permit, Jonathan would have mentioned some of the deficiencies in our local system, that cause a woman not to feel as protected or that they have access to reliefs. And it is true, the United Nations and the World Health Organization has in fact dubbed domestic violence the shadow pandemic. Because of the lockdowns and the restrictions that have been imposed for the public security, for public health, a lot of women now are trapped in abusive homes and abusive situations, and they don't know where to turn. So they have in fact recognized that the pandemic has resulted in what they call the shadow pandemic, and they're saying that there's a bigger need even now in the midst of the pandemic to prioritize addressing violence against women and to prepare for the government, to prepare and introduce response and recovery efforts. So you would see in spite of the fact that our courts are closed and we are restricted and there are certain guidelines in the practice directions that have been issued by the judiciary, you would observe that under the actions or the types of matters that have been deemed to be urgent, domestic violence is right there, almost pretty much at the top of it, because governments have been urged by the World Health Organization and UN Women to implement systems that protect our women in spite of the pandemic.
So how do you, we have these systems in place, right? But how do you, I don't know if access is the correct word or prove is the correct word, especially in cases of he may be violent, but there may not be a mark, right? So he may hit you. And I actually had one of the survivors talk about how he would squeeze and he would do things to her, but there was no evidence to show that. It was basically her word. I mean, unless you're brave enough to take a video camera and tape the situation. And even in the case of sexual abuse and in the case of the emotional and those that are patterns, how do you prove or how do you show that?
Well, I would just take a jab at that. That is, well, for domestic violence, the balance, it is on a balance of probability. So it's a lower standard than a criminal standard. So it's a lot easier. So a woman can go with her own evidence and testify that I am continually being abused. And the magistrate is sympathetic in those cases. She will get a protection order. She may not get legal costs and reliefs and get to put the man out of the house, but she will get some relief. For the criminal aspect with rape, that's a very high, but that's beyond a reasonable doubt. So that one I have, my first moot I did in law school was a rape case, and I tried to prosecute and lost because again it was one victim's statement against the alleged perpetrator. So that's very, very difficult, and that's how the justice system is. So in those cases, there are other everybody's on WhatsApp and social media now. If I always tell people if they can get the other person to admit that they did it in an email exchange or WhatsApp or a voice note, that's a potential piece of evidence. But it is, harkening back to the point, for a domestic violence case, there's a good probability of success on your own testimony. It's not impossible.
And let me piggyback on what Jonathan said. Some of the steps that we recommend women take, once there has been an act of abuse, make a police report. All right? Get out. If you say you're going by your friend, you're going to the grocery, you're going to work, whatever the case may be, and make a police report. And when you make the police report, ensure that you get a receipt. And sometimes the police like to mark made a report of information. No, ensure that when they put the report, they put domestic violence. Now, in some cases where there were acts of physical abuse or sexual abuse, the police would also send the female, some of them may even accompany the female to the district medical office or the health center to get a medical done. All right. And that medical sometimes would do their various testing and assessments and make certain findings that they send back to the police officer for formal charges to be laid. Okay. But in the event that, you believe that you are being abused, make a police report. Then we recommend as well that the good thing about the domestic violence legislation, as Jonathan would have highlighted, you don't need an attorney to proceed. All right. Now, an attorney would be able to argue the law and establish, the factors and the criteria to establish the abuse. All right. We know how to utilize the facts to establish the criteria of the offense. However, as Jonathan would have indicated, you could go to the magistrate and express, well, when I wanted to go somewhere, he said I couldn't go. He left home and he locked the door. So the children and I were there and we didn't have anything to eat. And, whenever I have to go out, he insists that he has to carry us. He's calling my phone all the time. When I'm at work, he calls me 10 times a day. So you could give your evidence, and the magistrate, knowing the various factors to establish the offense, they themselves, as Jonathan said, they are sympathetic because they understand a lot of the times the impediments that really inhibit women from coming forward in the first instance, and in the second instance from seeing a matter through, because they don't have the support systems around them. So the magistrate is very attentive to persons who bring allegations of domestic violence. And when you have the police report to corroborate that, listen, I didn't just stay quiet, I took action, you may be able to call witnesses, because some neighbors may be hearing of the abuse and they may be willing to come forward to support you in your plight. Or you may have complained, you know, to somebody to say, keep the children, to get the children out. And you know, because a mother's first mind or thought is towards the protection of her children. All right, she will probably stay and take blows, but you know, just get the children out. I don't want my children to see me like this. Or a friend may have come to pick you up to carry you to the hospital. So those are persons that you may be able to call as witnesses, but your evidence of itself could stand before the court of law. Now, I want to highlight as well that the domestic violence legislation does indicate the factors or who can bring an application for protection order, and it highlights that it's anybody, including a spouse, a member of a household who is living and resident in the abusive home, a child, you know, a dependent, a parent, or a sibling, you know, of somebody who is aware of the abuse. All right, a person who just has a child in common. So they may not necessarily be living in the same home, you know, but it is that they share a child, and, you know, whenever they have to interact and that kind of stuff, there is abuse. So even that person is permitted to bring an application for domestic violence or protection order. And a person who is in a visiting relationship. So even that, where you just go and you visit and you come, but he hits you too slap before, or he visited you one night and you weren't in the mood, but he insisted. All right, those persons are allowed under the legislation to bring an application. Now, I want to highlight as well some of the factors that the court will take into account in granting a protection order. That's the most immediate form of relief that you can seek. All right, now the reality is it effective? I endorse what Jonathan said earlier. Without the other social institutions and support systems, it's not very effective. It's just a piece of paper. All right. And we know that some women have secured a protection order and they did not necessarily reap the protection that they had expected, and they had very unfortunate ends. However, it is at least an action, an immediate action and recourse and relief that is available to the female. And so we recommend that you take it, you visit the social services department, social welfare divisions, to see what additional systems of support could be given to you in the circumstances. All right. Now, as I was saying, the court, when granting a protection order that is outlined in Section 7 of the Act, you know, it talks about considering the nature of the abuse, the history of abuse, the pattern of violence that has occurred, whether the person would have applied for a protection order previously. So, in other words, so that protection order did not serve as a deterrent to the perpetrator. So the court will have regard to that. The need to protect the applicant and any other person, inclusive of children or dependents, you know, who has to benefit from a protection order being given, the welfare of children, any accommodation and or needs of the applicant and the persons who are to be protected, the hardship that might be caused as a result of such an order. So, you know, one of the reliefs that are available under the Domestic Violence Act is not just a protection order, but what we call a protection and exclusion order, where the magistrate is convinced that the nature and pattern of the violence, the seriousness of the act that has been committed against the person suffering the abuse is of such a grave nature that the perpetrator needs to be evicted from the home. All right. But of course, in doing that, the magistrate would have regard to any hardship that that person may have or experience as a result of being evicted. All right. Income, assets, financial obligations of the parties, the need to preserve and protect the institution of marriage and other relationships whilst affording protection to the vulnerable, and any other circumstance or factor that the magistrate thinks is relevant to the proceedings. Now, I want to highlight that there are other reliefs other than the protection order. The magistrate could order that the perpetrator pay maintenance towards, if the victim or the person seeking to escape the scenario does not have the financial means, the magistrate could order that the perpetrator assist financially with the upkeep of the person seeking to escape and the children. The magistrate could, as I said, order the perpetrator to vacate the home. The magistrate could order counseling or other social services to intervene, to assist, because we really don't want that at the end of the day they escape to go back because of circumstances, because it's hard. All right, the magistrate could order certain frequent reports that a probation officer or social services officer be assigned to, help the person access, whether it's the food card or other grants that are available. All right, so there are other ancillary reliefs that the legislation does provide the courts with options to help protect and preserve and empower, because that's what we really want, to empower the person who is escaping an abusive home.
So I just want to ask you, I know you spoke at length about the protection order, but was the protection order actually say or involve? Is it that the abuser will not be allowed to come within X feet of the person, or what exactly will the protection order say, or is that dependent on the situation?
It is dependent on the situation, and what it generally says is the respondent shall not engage in any act of physical violence towards the applicant. The respondent shall desist from using any threatening, obscene, or insulting language towards the applicant. The respondent shall not or shall vacate, rather, I should say, the home which the applicant and the respondent share. The respondent, if it's a case of financial assistance also needed, the respondent shall, pay to the applicant the sum of so and so towards their financial maintenance. The respondent is prohibited from watching or besetting the places where the applicant would frequent. The respondent is prohibited from destroying the property or preventing the applicant from the free use of their property. So it varies based on the evidence that is presented. The magistrate has a wide discretion to provide relief and protection under the Act.
So it's not that in the case, because this, what you're talking about, actually have a real life situation with that I know someone going through this, where they are divorced, but the partner or the ex-partner continues to verbally and mentally abuse the ex-wife. But they share children, so she still has to drop and he still has to, whatever arrangement they have. And so I would want to understand, in the case, let's say she got a protection order, is it that relationship they have to facilitate the children knowing both partners and whatever that agreement is that impacted by the protection order?
Yes, because sometimes if it is that me dropping the children off at your home leads to some sort of unsavory altercation between us, the order can be amended that the children be dropped off. I mean, the magistrates avoid this at a police station or at another public place. They don't like the police station because, it's children. So remember, the welfare of the children is still the paramount consideration of the magistrate, right? So, but in really serious circumstances, that is an option, right? But sometimes they said, at the home of, if there's a relative of the respondent that you trust, for example, he mightn't hit you in front of his mother. We don't know. All right. So you drop them off at the home of the mother, and he collects the children from there, sometimes in a car park in like Trinity Mall. I had an order already where they had to collect the children from Windsor, the Windsor parking lot in Arima. I think now it's the KFC and Pizza Hut rather complex, right? So the court could, in those circumstances, do variations of the order for the protection of the parties involved. That is quite possible. But yes, she can definitely bring an application for a protection order.
Okay.
And one more point. Also, just remember that with different situations we're dealing with, a woman can also apply for child custody. So if she wants to have a situation where she doesn't want the husband or child father, common law husband, to have any more full custody rights, they can apply it with that together with the protection order on the same day and have those dealt with, together.
Okay. And is there any other sort of relief that persons in these situations can apply for, or is it that once you when you start going through with the protection order and those things, it is really for it to go through the court.
Well, there's the interim order. Well, Renee had something to.
Oh, sorry, go ahead.
No, go ahead. Yes, no, she could go ahead. I'll piggyback on him when he's finished.
So on the you don't have to win a trial to get protection. On the first hearing, you can actually apply for an interim order, and if there's a serious situation and serious danger, even if the other person wasn't served, you can get a 21-day order protecting you until the things go forward. So it is not that you have to prove everything and fight a big trial like you see on TV. It was designed to help women.
All right, and let me just highlight as well, we are dealing with the family law arm of civil law. But as Jonathan would have highlighted, there is also the criminal procedure that could, so an act of domestic violence, especially with respect to physical violence, that's why the legislation, the Domestic Violence Act, reference the other pieces of legislation that are its cousins, I like to say. So for physical abuse, for example, it references any act under offenses against the person. All right, so something like an assault, a common assault, or an assault occasioning grievous bodily harm, etc. If you get bruised up and kicked up and broken ribs, etc. So there is the possibility as well that the police could decide when you make the report, depending on the gravity and seriousness of the act committed against you, they could lay criminal charges. Likewise, under sexual abuse, references have been made to the Sexual Offences Act. So while you pursue the family law arm, which is to apply for the protection order to get protection in the interim, as Jonathan would have mentioned, the police could also bring formal criminal charges, which would be heard, and that, of course, would lead to a guilty or not guilty verdict and some form of sentencing thereafter.
Okay, does that involve on the mental side as well?
With respect to the mental, not necessarily. There is the offense of harassment, where it must have happened on at least two occasions within a 6-month period. And the law states that the person knows or ought to have known that their action would result in you, suffering distress. So that does touch and concern the mental health aspect of it, and even the emotional abuse. So you will have to establish those criteria. Twice, a period of 6 months, it caused you distress, and they knew or ought to have known that their behavior would have caused that.
Okay, so I know we wanted to talk a little bit about why the domestic rate in the country is so high. Jonathan, you want to speak to that?
Well, as to why that is complicated, but as a society, we came from colonialism, is the result of slavery and indentureship. So all of our ancestors have experienced abuse, and then we have a political system where our politicians abuse one another on TV every day. So it is part of the culture, and like I always notice that the certain political commentators, if they cuss and get on like the ones who, like, we all say this man has the characteristics of an abuser, people are attracted to that because that is part of who we are as a society. And we need to deal with some deep cultural issues about just basic respect for other people. So it is deeply embedded, and we need to do the cultural change. And then over the last 20 or 30 years, I must say no administration, they will pay lip service to the issue, but billions of dollars go down the drain in building stadiums and things we don't really need. And then we don't see the money putting into psychological counseling for all of these abusive, crazy people who are killing their wife and themselves, and properly funding the directed public prosecutions to put the murderer of Andrea Barrett and all these people in jail and win. We will lose a lot of rape cases. From what I'm told from DPP, it's a very low conviction rate. It's very scary. So there's a lot of factors. You need to do like a PhD thesis and 5 years of research.
I mean, it's amazing that you mentioned that, because, I don't really follow politics, honestly. I'm not a confrontational person, and the sort of environment that is, I don't really follow it. But what I find is generally what you spoke to in terms of colonialism and where we are now and the culture that we are embedded in. When you look at how persons in the public arena respond to things that are happening, it is abusive. The things that are said, you know, I don't want to shine a light on anyone, but when you look at someone addressing a situation and saying, "Oh, you move from there now," or "Oh, you harassing me," you know, those things. And then when you look at, you have a topic that we are discussing that is very important and it is very relevant. And the way in which it is handled is, well, I'm not going to answer that. You should read what I said three days ago or whatever. It doesn't support constructive and intelligent discourse and conversation. And that is one of the reasons that I also wanted to have the series, because the series that I am having is not from a point of let's figure out who is to blame, let's figure out who we can shame. It is from a point of healing and compassion for the persons that are going through this, and so that they would recognize that they don't have to go through what they are going through, especially in the space of a woman. And I know men are affected by this as well. But, you know, woman, whatever religion you are in, you were brought up to think that you have to be this sort of domesticated person in a relationship, and you kind of have to sacrifice your rights in order to make the other person happy. And that is what I really think we need to move away from. A woman should feel free to be who she is and to be authentic and to chase the things that she wants, and to have a partner that supports her, and she of course supports him. So thank you so much for that, Jonathan. We are coming at time, and I do want to get to a couple questions. Before I started the series, I asked generally on Facebook if anybody had questions that they would like to ask a lawyer or a therapist. And I did get a couple questions, so I would like to ask them at this point, unless you have anything else you want to add. Okay, so this one was 2 questions, but I feel they're intertwined, so I will ask both of them together. Can I move to another country with the children away from a narcissist father? And how do I show emotional abuse of children in divorce court?
All right, so the short answer is yes, it is possible. However, it will be an uphill battle. That is because generally, when divorces are undertaken or addressed by the court takes the welfare of the child as a paramount consideration in dealing with the arrangements for the children. And ideally, children should have access to both parents, because the input and influence of both parents on the lives of a child are different. All right, so really, a mother cannot be a father to a child. All right, it's different. While you may have to fulfill both roles, it does not necessarily mean that you could provide those intrinsic roles and influence that a father would have provided, and vice versa. So the court would generally lean towards a position where the child, or the arrangements for the child, are maintained, or we call it the status quo is maintained as far as possible, as though the marriage had not broken down. Okay, now what happens here, if it is, however, that you can establish that the welfare of these children will be compromised by continuous exposure to the father, the court may be minded to reduce and altogether withhold access from the father to the children. So it would mean, therefore, that you would have to, in the divorce pleadings, make the application related to the children. In your affidavit, outline your evidence why you are of the view that the children should have limited exposure to the father, and he should not have, whether it's liberal access or structured access every other weekend, Fridays to Sundays, etc. So this would include things like he's continuously verbally abusive towards them. He is physically abusive towards them. I have had a case where a father was sexually molesting a son. So those things would cause the court to intervene very quickly, because they want to protect the child. Now, that being said, not just because you allege it means that the court will act, because the court has to act under the purview of the law. So what generally happens, the court often would assign what we call a probation officer, or some sort of social services unit or officer, to investigate the circumstances. So at some point in time, they may want to talk to the child, and they know their approaches to make inquiries and what they look for to determine there has been abuse. I had one matter where the court said, while it is inconclusive that sexual abuse occurred, there are sufficient indicators that something happened. They cannot say that it was sexual, but the report came, there was sufficient in the determining factors rather, or manifestations of something having happened. And so they cautioned the court against access by the father. So it is possible. In those circumstances, you could seek to have sole custody of the children. Again, the courts would lean towards joint custody because remember, it's equal access to both parents as though the marriage had not broken down. All right. But you could, in those circumstances, petition for sole custody. And once that order is granted, you can, in fact, move away and leave the jurisdiction with the child. The court would still advise that some sort of system be put in place. So I have a matter where the court has ordered every other day for a period not less than 5 minutes, the children should have a phone call with the father. Now, it's his prerogative to call. It's not that the mother is going to be picking up the phone to call. If he wants to speak to the children, at least he has every other day, no less than 5 minutes, I think between the hours of 4 to 6 or something like that. So they would still try, because the court looks at the fact that notwithstanding that the relationship between you and your spouse broke down, they still try to put something in place for the child to have a relationship with the parents. All right. So to answer that question, yes, it's possible, but you will have a lot of proving to do within the court.
Okay. Do you want to add anything, Jonathan? I see you thinking.
No, just thinking in general. Renee covered everything I could imagine.
Okay. Okay, so thank you everyone for joining today. I would like to remind you that this is not legal advice. It is merely guidance so that you can be guided in whatever situation you are going through and make decisions to help you to seek the professionals that you need to seek. That is really up to you. All right. So if you are in a domestically abusive relationship and you need to call the domestic violence hotline, that is 800-SAVE. At the end of the series, I will also post the website to access a therapist if it is that you need to access coping behaviors through these situations. Thank you everyone for joining us. Thank you so much, Jonathan and Renee, for sharing all out of your own free will and out of love and compassion for humanity. Thank you everyone. Bye.